Welcome, ladies and gentlemen. My name is Adam Gauthier, and I would like to invite you to our next live. I am glad to introduce attorney at law Nina Zeman,
Good morning, everyone.
who works at my law firm, who helps to cope with our clients' problems. And today we will be talking about establishing paternity in Poland.
I have some questions about this topic. Please, could you explain what does the term paternity even mean?
Paternity in legal terms confirms that a man is the father of a child. The legal bond in question generates both rights and obligations between the above mentioned, which are not created by the biological bond alone.
And what is the presumption of paternity, and what are the other ways of establishing this link?
In the case of marital relationships, there is a presumption that the mother's husband is the father of the child. However, outside of the marital relationship, when the aforementioned presumption does not apply, there are two ways of establishing paternity. The first is acknowledgement of paternity, which is done before the head of the register office. In this case, the father of the child declares that the child comes from him. Paternity may be acknowledged for a child who is conceived but not yet born. However, in such a case, there is a risk that an incorrect acknowledgement of paternity may occur. The situation in question may arise if the incorrect acknowledgement of paternity, the situation may occur if the father of the child is convinced that the child is biologically his, and it subsequently turns out that is not the case. In such a case, the father is entitled to bring an action to establish that the acknowledgement of the paternity is invalid.
For this explanation, and what is the judicial determination of paternity necessary?
If there is no agreement between the parents of a child on acknowledgement of paternity before the head of the registry office, then one way of settling the issue in question is a judicial determination of paternity. It requires an action before the family court. An action to establish paternity under the child's comes of age can be brought by both the child's father and the mother. Once the child has reached the age of majority, the child himself or herself may bring an action to establish the paternity of a particular person. The public prosecutor, on the other hand, may make the request at any time. Notably, unlike in the case of an acknowledgement of paternity before the head of the registry office, it is not possible to bring an action to establish paternity before the birth of the child, for example, during the pregnancy of the child's mother.
And what if the husband of the child's mother is not the child's biological father?
It is important to note that there may be also a situation where the mother's husband is not the biological father of the child. In such a situation, the biological father of the child will not be able to make an acknowledgement before the head of the registry office. Pursuant to the provision of Article 62 of the Family and Guardianship Code, if a child born during the marriage or within 300 days of its cessation or annulment, it is presumed that the child comes from the mother's husband. Thus, in any such case, the mother's husband or ex-husband, as it were, will automatically be presumed to be child's father. In order to refute this presumption, it is necessary to sue for a denial of paternity. Only a final judgment denying the paternity of the mother's husband will allow an acknowledgement of paternity by the child's biological father. What is particularly important is that the child's mother can only sue for the denial of paternity within 6 months of the child's birth, and the mother's husband within 6 months of learning that the child was born. And this time does not apply to the public prosecutor. So if child is basically 6 months or older, in order to establish who the right father is, we usually need the prosecutor's help.
And last question, what are the ways of proving paternity?
Currently, the most common way to prove that the man is the father of the child is through the result of a DNA test carried out either privately or by court order. And it is also quite important to mention that if any party questions a private test, then it would be necessary for this test to be led again by an expert asked by court. So in any other case, if there is the risk that the party might be questioning such an evidence, it's best to ask for the court expert anyway.
Thank you very much for explaining this topic to me, and yeah, thank you guys.
Thank you very much for your attention, and welcome to another live we're going to have next Wednesday. Have a nice day.
Have a nice day. Thank you.